We'd like to welcome everyone to Financial and Estate Literacy. We're also a not-for-profit, and our mission is to provide you with a education on financial and estate planning in a safe environment. So none of our presenters are going to contact you. None of the charities are going to solicit you. And all of these programs are going to be put on our website so you can review them again later on if you have a question. All of our presenters are volunteers and they don't get paid for doing this, and we really appreciate them. Today's session is Leslie Daff. Leslie, you want to come on screen?
Hello there. Hi.
Good to see you.
Good to see you.
We're going to talk about wills and trusts today. We've already done the kind of an overview of estate planning. We talked a little bit how important title is, and when we try to when we have an asset. And in addition, we did the durable power of attorney, and we did the advanced healthcare directive. So today we're going to focus our time on a little bit on wills, but mostly on trust. And so, but before we get started, we need to know a little bit about you.
Okay, good.
And,
Do you want to share my ask first form, or you just want me to talk?
let's just talk, because your ask first form is going to be on the website. Not today. Hopefully by the end of the day it will be. So not a problem there. But anyway, Leslie, what kind of educational background do you have?
I have a undergraduate degree in business, an MBA, and a JD law degree. And I've been practicing in this particular area for about 23 years. And I'm a certified specialist in estate planning, probate, and trust. And let's see what else. I guess that's the basic. I do probates in every county in California, do trust administrations, do estate planning, and that's it. Nothing more.
Okay. And your offices are located where?
Primarily in Laguna Beach. We have a satellite office in Irvine, but mostly we meet in Irvine. I mean, in Laguna Beach.
Yeah. And then you're licensed in the state of California. So if we looked you up on the bar, we'd find you and your address, and we would find that you have absolutely no negative marks on your background.
Right.
And we need to remember to, even how sweet and nice and wonderful and educated Leslie is, we always need to kind of check the bar just to make sure that everything is cool. How do you charge your clients?
I charge flat fee whenever possible. So even usually on a 15-minute phone call, I can give a flat fee right there. So that's what I try to do. I just can figure out the complexity of the plan. Even for trust administrations, I typically can give a flat fee for that as well. And probate is flat fee, so it's all flat fee, pretty much.
So you rarely charge an hourly rate?
Rarely, unless I can't get my arms around what I'm going to be doing.
And what is that hourly rate?
For trust admins, I typically say it's $450, and for estate planning, $495. But like I said, I rarely do that, so it's hard to. Yeah.
Okay, let me give you an example, and you tell me what you would charge. I'm married. I have one child. I have approximately about $1 million in a brokerage account. I have a bank account. I have a car, and I have a house. My total value of my estate is $2 million. What would you charge? And remember, I'm a friend. All your clients are friends, right?
Maybe like $2,500 for the complete estate plan with everything in it. It's not based on dollar, like value of the estate. It's based on how much drafting am I going to do? How much work am I going to do? A lot of times,
blended families, for example, you're disinheriting someone.
Yeah, 63 beneficiaries. Yeah, then it gets more complex.
Property in more than one state.
Yeah.
So that's complexity.
Yeah.
Multiple marriages. Yeah. So Do you provide a free consultation? So
I
somebody
do,
can call you and ask you a couple of questions
yeah.
and find out what it would cost them?
That's what I always do. Almost always they call and I just ask them a few questions and give them a flat fee price quote and then take it from there. Yeah.
How do you feel about reviewing other attorneys' documents?
I do that. I do that at no charge. You know, it's usually they want it reviewed for potential changes and things. And yeah, I'll look at that and yeah, no problem.
Okay. Alrighty. And are you associated with anyone who sells annuities, gives you referral fees, et cetera, et cetera?
No. Mm-mm.
You're a clean kid.
Mhm.
Okay, let's go to the outline and we're gonna uh do if you
Do I
can
want to share my screen or is it right here or is right here?
here it comes.
Okay.
There it is. So here's Leslie's contact information and and the outline is going to be on our website. So we're sorry that it wasn't there earlier today. So let's go to intestate succession. What does that mean, Leslie?
Well, every state has a laws of intestate succession. So if you die and there's no beneficiary named on things and they don't know where it's going to go, the laws of the state will determine. And
So,
everybody,
so essentially you have no documents.
yeah, if you have no trust or will or anything, and no beneficiary designations on things. But so a lot of people don't do planning. 60 to 70% of people they say don't plan at all. And a lot of married people think, well, it will all go to my spouse. But that's not always the case. The community property will, but again, it will go through probate court first. And then separate property will be divided between your spouse and children if you have any, or your spouse and your other next of kin and things like that. If you have two children, for instance, 1/3 will go to your spouse and 2/3 will to your children. So it doesn't always just happen the way you think. So it's better to plan. And most people, the first step in planning, they think of a will. And when you think of a will, it's very easy to create one. Of course, you can do it by hand, all in your own handwriting, that everything to my spouse or everything to my kids or whatever. And that's sufficient. But let's talk about what a will does. It lets you say who gets your assets when you die. It's where you nominate a guardian for minor children, and you can avoid intestate succession and name somebody to handle your estate. So again, no will versus will. No will going through probate will go to intestate heirs. With a will, you can name the person handling it all. It will still go through probate, but it will go to the beneficiaries you name. Um, but the types of wills are the holographic will I mentioned. You just do it in your own handwriting and sign it. You don't even have to date it. It doesn't have to be witnessed or anything. But it must be in your own handwriting. You can get a statutory will form in California, and you have to have two witnesses on that, or typewritten, which is usually done by an attorney or by yourself. But when we find people can sometimes type it up and then they don't get witnesses, but you have to have witnesses. Now, will or not, if you have nothing, or if you have a will, it's going through probate. Probate court is expensive. The court will supervise it, and there's statutory fees involved. And it's taking me a year minimum, sometimes two, sometimes more
Yeah,
to get
it's
things.
the courthouse is very busy.
Yeah, it's a minimum because you have to wait for the hearings, you have to wait for creditor claims, you have to wait for the final petition.
Yeah,
But
and it's expensive.
it is. So $1 million asset, even if you owe $1 million on it, it's going to be 23,000 in attorney's fees. And for every million over that, it's another 10,000. So, and then you have the court filing fees and everything, usually running about $1,500 or about. There's extraordinary fees for, litigation or unusual, sales of property and things like that. And everything's public. So anybody could look up that file, see all your beneficiaries, all your assets and everything.
Yeah,
But
but remember that when you die, it is public record.
it is.
So uh, I just want to mention this because what happens a lot of times is first of all, the vast majority of people don't have an estate plan. which is really amazing. So we're in a county of close to 3 million people. So every year when someone dies, the courthouse is just jammed.
Okay.
And now they have literally have moved the probate courthouse to, is it Costa Mesa?
Yeah.
Yeah, Costa Mesa by IKEA, just because it's so busy. You got a brand new group of judges just recently, and so it's going to take some time. But procrastination is usually the number one reason why people kind of hold off on an estate plan, and then when they get older, they just don't want to spend the dollars on it. And
Yes, that's
look at
exactly it.
yeah, and look at the dollar amounts that you're going to be paying when you go through probate and how much time it's going to take.
I know. I
It's
always think that when I undertake a probate, I always think it would have been so easy had they
yeah,
just deeded this to a trust. Yeah. But
it-
but again, it's the cost. They're worried about it will cost. People don't like to go to attorneys very much.
no.
They're worried about the cost. That's why flat fees, help. It doesn't, they're not on the clock. They
At
don't
least
worry.
they know exactly kind of what they're looking at. So I
Yeah.
think a flat fee does help people
Yeah.
kind of,
Yeah.
you don't give away toasters with your estate plan or anything,
Yeah.
they
Yeah.
just get a nice document and wrapped in a nice binder.
Yeah.
Um,
I
and
think
is there
most
anything
people do.
positive about probate?
If it's a super complex estate and you have complex and or conflicted, it's better in some sense to have court oversight and have the court approve everything. Everybody has their day in court if they have a problem with anything. So in that case, there might be a case for it. Yeah, for
Yeah.
sure.
So let's talk a little bit about avoiding probate. How do we do that?
Okay. Well, I will skip over this because not, well, I'll tell you a couple things. I don't, I don't recommend doing these things because, well, anyway, you can put beneficiary designations on things and everything, and it can avoid probate. But the problem with that is that you don't have anybody stepping in during incapacity. So let's say all you have is a bank account of $1 million. You put a pay on death beneficiary on that. That's great, but who's going to handle it if you're in a coma and they have to pay your medical bills and everything like that? So I don't, it's not my favorite way of doing it. I like the revocable living trust plan, but also beneficiary designations you can put on everything, even houses and things. But I just and also people do it yourself estate planning by putting a child on title. We see that a lot too. And I don't like that so much because, if you wait till you die and give it to them, you get a stepped up basis on the property. And do you want me to explain that?
Yeah, yeah, yeah. Let's,
Or
but
just
first of all,
keep going?
pay on death is usually you can go to your bank, tell the teller you want a POD in shorthand, paid on death, and they'll ask you, well, who? And you name the beneficiary, and then when you die, the individual goes to the bank, shows their driver's license and death cert, and they get the money. It's a great way to get some monies quickly to a beneficiary, but do it in small amounts. Uh, I've seen people do their entire estate plan with paid on death or beneficiaries designations, and it provides no flexibility whatsoever. And when you do it, you don't know what the future is going to hold.
Right.
So one of the things too is that they put kids on title, joint tenancy. What happens from a financial tax point of view when you do that?
Well, first of all, yeah, if you put them on title to your house, it's a gift, of course. Things like when you put them on a bank, there's so much do-it-yourself planning that goes awry this way. A parent will put a child on bank accounts to help them with things, and they even when they have a trust, and then it goes to the child, not through the trust or anything. It's not a so or they'll put the child on title thinking the child will share it with the other kids when the person dies. It doesn't happen that way often. So it's just uh, it's better in most cases to have assets in the name of a revocable living trust. Your successor trustee steps in upon incapacity and death and handles everything.
Let's talk about step up in basis. I have Amazon stock that I bought for $10.
Mhm.
And now it's worth $110.
Yeah.
What happens if I give that stock to my child today, my adult child?
Yeah, if you give it to your child, and if it's, well, anything over 18,000 is a gift for which you have to file a gift tax return. But let's say it's under that. It's $10, I guess it is. And then the child will get your basis in the stock. So their basis is $10. So if they sell it the next day for the or sell it
100,
for
yeah,
110, they'll have a gain of $100, and then they would pay capital gains tax on that,
yeah,
roughly 30-ish percent, 35.
yeah.
50.
So, but if I left it to him in my trust, what would happen?
If you leave it to them and they get it at death, then they get a stepped up basis to fair market value at date of death. So 110,000, I'm 110. And so if they sell it the next day for 110, there's zero gain. So
Yeah,
comes into play in a big way in real estate when the parent has a house they paid, 50,000 for, and now it's worth 5 million or something. We've seen that. It's just crazy. And so do not really want to put your child on title or give it to them while you're living, unless there's other reasons. There's some property tax issues in the
yeah.
past. Or
Where, you know, what I find from most people is that when they purchase a home, they learn about title, how best to hold title from their real estate agent.
they do. They do.
And boy, that's the wrong person to ask as to how best to hold title. What happens? We talked a little about joint tenancy with right of survivorship because that's seems to be the most common way to have title, or at least for the public. What is community property with right of survivorship?
Okay, well, let me first say that you're correct that when the escrow will usually have, if you don't tell them, or they'll just tell you joint tenancy with right of survivorship. We see it all the time. If you're married, you would want to hold it as community property because, well, joint tenants, when one joint tenant dies, the deceased person's share gets a stepped up basis, but the other tenant, he stays at the low basis. When you own it as community property, then at the first death, there's a full step up in basis on the entire property. So that's beneficial. So typically when a client comes in and has a joint tenancy deed and they're married, we'll transmute it on the face of the deed into community property so that they get the full step up without any question.
Yeah. Yeah. So we got, if what happens if somebody is single and just have it in their own name?
Well, there's a stepped up basis at death for somebody.
But that means probate, correct?
Yeah, but definitely
Yeah.
if it's in your sole name and not in a
Full
trust.
name, you're going through probate or incapacity. There's nobody to help you.
Right,
You're talking about a conservatorship there,
right.
so people who are single, man,
Mhm.
please have a revocable living
I
trust.
agree, because
We're gonna get there just a second, but I want to go through a couple of other ways to have title. One is a tenancy in common. What does that mean?
tenants in common means it doesn't go to the survivor when one of the tenants in common dies. So each of you own your independent interest, and you can, it goes according to your own estate plan or lack thereof. It goes according to your intestate succession. You can deed it to your trust. It can go by your terms of your will through probate, but each tenant in common, it goes to according to their own estate plan.
Yeah.
Whether
So
you have joint tenants with right of survivorship or community property with right of survivorship, it goes to the survivor when the person dies.
so title is absolutely important, and people need to understand what the ramifications of, depending on how you hold title, what those are during your lifetime and at death. So uh, the best way to hold title you have here is a revocable living trust. So
Yes,
let's
that's
get started on that.
yeah, that's the way. That's the way to handle things. Oh, let me just say a couple things.
Okay.
There are some summary procedures for people, you know, who have small. And by the way, I don't always force a trust on people, because I've had people who are terminally ill and they have just a bank account. I say, yeah, just do the POD, whatever. But in a perfect world, you have a trust. Now, there's some summary procedures, like if you have you have a small estate that's under, a certain amount, you can just have a small affidavit you give to the bank, whatever. Small properties of small value, all these are summary procedures. Spousal property petition is if your spouse dies. We're doing one right now that yesterday came in. Spouse died, left account in his sole name. She can't get out of it, but they were married 35 years. We can say that was community property and it's a summary procedure. So it's a petition to the court. But anyway, so there's ways around some things. She thought she had to go through a full probate, but no, so that's good.
Yeah. So remember the amount of monies that you can have in your own personal name and avoid or have a small estate affidavit handle it is 184,500, I believe something like that. Keep your eye on that because that's important.
Mhm.
Okay.
Yeah.
Revocable living trust. What is it?
Revocable living trust is, I think of it as a contract between you as the grantor who grants assets to your trust, or it's also called a trustor, grantor, trust maker, settlor. There's different names, but I call it grantor because I say they're granting their assets to the trust. And it's between you, the contract is between you as the grantor and the trustee. You're the trustee who's managing the assets. The reason for the split in the split is that you name successor trustees to step in upon incapacity and death, to step in without any court involvement. So no conservatorship during incapacity and no probate at death. And then after, you pass away, well, after you become incapacitated, your successor trustee steps in and definition of incapacity is in your trust as you want it to be defined. And then you go through trust administration instead of probate, which is, 90%, could be up to 90% less than a probate cost. And then it goes to the beneficiaries you name according to the terms of your trust.
Leslie, do all wills go through probate?
Yes, all wills go through probate. Yes.
So
for anything to go through a will, it goes through probate.
yeah. And so, and there again, it's depending on the amount, what the level of assets that you have, whether it's a long probate or a short one.
Yes, you can do summary probate procedures. Yes. Now, go ahead.
No. One of the things is that someone had asked a question is that they haven't updated their trust or estate plan in over 10 years. And can they speak to either one of us afterwards? The answer is absolutely yes. And Leslie will take your phone call. I'll take your phone call or email address, and we can help you out. The good news of our program is that I am not a practicing attorney, so I can't do your estate plan for you. I'm what's called a professional fiduciary who works with the attorneys. So the good news there is you do have to go see an attorney to draft an estate plan. And then hopefully somebody like a Leslie who's certified, who's California licensed, and who has over 20 years of experience. Because today, let's talk a little bit about this. Today is not about taxes to do a good estate plan. It's about you knowing their family. You want to comment on that, Leslie?
I'm sorry, I was looking at my slides. You have to repeat it. Sorry.
Okay. That's okay. In drafting a revocable living trust or an estate plan to people, for most of us, you're drafting it based on the dynamics of the family versus where maybe 10 years ago, it was very tax driven.
That's true. Yes, there's a lot of family dynamics. Yes, it's all about that. We have tax provisions built in, and we put a lot of benefit provisions that we can trigger if tax laws change and everything, but it's more driven, you're right, by family dynamics. Yeah.
How age of their family that you're benefiting, physical condition, mental condition, drugs, gambling, can they handle money? There's all sorts of issues that need to be discussed with your attorney because they can't draft a good plan unless they know it. And do if you have an item like a house titled in the name of the living trust, how would that read?
Well, it would read Peter Kote, trustee of the, it would be titled from, it would be deeded from you as an individual to you as trustee of your trust. Peter Kote, trustee of the Peter Kote Trust, dated X date. Yeah.
Okay. And do you homeowners insurance, or is everything, does it affect the property tax basis when you change from your personal name into the trust name?
No, we tell you to notify your insurer because sometimes they want to add the trust as an additional insured for some reason. But it doesn't change your property tax at all because it's although it's a transfer, it's an exemption from reassessment. So we file something with the deed so it doesn't get reassessed.
So just to go back to a comment that we made earlier, for a husband and wife, whether or not they have children or no children, the best way to hold title is a revocable living trust. But if they don't have a revocable living trust, it is important that they have it as community property with right of survivorship.
Yes, community property with right of survivorship, because some institutions, like, well, for house, I mean, but even some bank accounts, they won't give it to the spouse if it doesn't say with survivorship. So that's important little tag on. Community property with right of survivorship is the way to go for a married couple who doesn't want to trust. But of course, we always think of what's the worst case scenario, and the worst case scenario is you die in a common accident and it goes through probate. So yeah, I still think it's better to have a trust. Yeah.
Yeah. Okay. So when
But
we
it,
have a trust, talk a little bit about why that previous slide. Okay. Da, 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 da. Here we
there it
go.
is.
Why is this slide kind of important to people to know?
This, yeah, this is important because a revocable living trust works, but if you put your assets, tiled them in the name of the trust. So, like I said, they sometimes create a trust. I always give them a to-do list too on their, we do the deed and everything we can do, we'll do, but I can't go to the bank and retitle their accounts in the name of the trust. I always say, go to the bank with your binder and retitle your accounts, your non-business, non-retirement accounts in your name as trustee of the trust. But sometimes they'll put a kid on with them. It's going to go to the kid and not according to the terms of the trust. So but that's really important. We need to retitle assets. We need to deed the property to the trust. We need to assign business interests to the trust. We need to assign the personal property to the trust. If things don't get into the trust, then we're going to have a problem. During your incapacity, perhaps your agent under your power of attorney. I'll go through all the things that go together, but in a future slide, perhaps we can get it in through your power of attorney. But if it's sitting outside your trust at death and it should have been in your trust, our last resort will be a pour over will, which we'll give you as well. A pour over will pour it into the trust because we didn't get it in any other way, but it will go through probate, and we want to avoid that. So
there's a question, Leslie. A person went to an attorney and he suggested that he be named as the successor trustee. What are your thoughts about that?
I don't do that. People ask me as well. I won't do it because it's setting me up for fees in the future. And I think that's a conflict of interest personally, unless he's not taking a fee. Now, every now and then I'll have a client who I really care about and they'll ask me if I'll be a trust protector for a particular reason.
Yeah,
So
we'll get to that in a little bit, but
I will
the
do that.
bottom line is attorney
Yeah,
shouldn't be named as successor trustee.
in those two instances where I say I cannot take a fee because I think it's a conflict of interest.
It is. Yeah. And in a normal trust, in a regular trust, does the successor trustee, let's say if you name the attorney, do they have the power to name a successor?
Only if you put it in the document. I always put in the trust that the last acting trustee can appoint someone. And I do that because I'm afraid if it lapses and nobody's there, they do their trust now and they live another 50 years, that it has to go to court. And we don't want to go to court.
Yeah. Let's go
Yeah,
to the next slide, but it's important to really read and understand your trust so that, because it's a contract.
it is. Yeah. Like I said, we already talked about this, but this is the slide I use all the time. When the people come in my office and I talk about the trust, even when they're signing the documents, we typically will review what are the reasons for the documents in an estate plan. The centerpiece of the estate plan is the revocable living trust, okay? But we have ancillary documents because I'll just tell you briefly again what the other ones are. You already know what the healthcare documents are for. You had a session on that. You had a session on power of attorney as well, but let me just explain how it works in conjunction with the revocable living trust. The trust is the centerpiece of your plan, but it only works with regard to assets being titled in the name of the trust. And then if something is not in your trust and you're incapacitated, we've also named agents under the same person named as trustee as the agent under the power of attorney, because they cannot act as trustee if it's not in the trust. But we're saying they could sign your name and get it in the trust before you die. They could handle things outside the trust, like canceling your gym membership, collecting your mail, filing your tax return. So you, as Peter probably knows, banks hate powers of attorney if you show up with a power of attorney and try to do things, but we use it to get things in the trust, and we'd
But it
have.
has to state that in the power of attorney,
Yeah.
that you giving that authority. Most powers of attorney don't, so you got to take a look. These
Yeah.
documents are really important that you understand them.
Yeah, we've used them to get things like if somebody's in a coma and we find their house isn't in the trust for some reason, they refinanced it and it was taken out. We'll have the power of attorney sign a deed getting in the trust before they die.
You know what Leslie, what I also find is, you have on the slide here, schedule of assets.
Yes.
And people think that, hey, my property is in the name of the living trust because it's on the schedule. Is
I
that
know.
true?
No, it just shows intent. No, it's not in the trust. And people call all the time and say, I bought a new house. I need to change my trust. No, they don't have to change their trust, but they need to make sure they took title in the name of the trust. Because anyway, but the schedule of assets is important for one reason, really. It kind of reflects what's in the trust, but we use it. Let's say that scenario happened where somebody died without the house in the trust. And let's say they refinanced, they had it in the trust, we put it in, they refinanced it, the lender took it out of the trust, they didn't get it back in. This has been an exact scenario we've had. Ideally, the agent would have put it back in the trust before the person died, but they didn't. But it was listed on a schedule of assets at the back of the trust. That's a classic Hagstad petition where you go to court on a simplified procedure and say to the court, they had a trust, they meant for it to be in the trust, it's listed on the schedule, these are the circumstances, can we get it in the trust without probate? And the court will say yes. It's always said yes.
But it will take
7 months.
but take 18 months, and it'll cost you $5,000 to $10,000. So
simplified, but yes, between 5 and 10, but it's be 7 months in court be found. We have to wait for a hearing date. Yeah.
Please, everyone, put a list of your assets on a yellow sheet of paper, and house. And right after that, how do you have title? Not guess. Take the title out and make sure that it's correct. Then put in your cost basis right after that, and then put in market value. And it'll give you a great snapshot of your entire estate if you do that on all the assets. Because if you have the most beautiful estate plan that Leslie has drafted, and you don't have title in the name of the living trust, and we call that funding the trust, then you're going to go through probate, and then you're going through a trust administration.
Right.
So it's not a great idea. But let's touch just briefly on why is it called a pour over will?
So when you have a trust, the only reason we have a will is to pour over anything that didn't get into the
So the
trust.
distribution line in your will states
It goes according to the terms of your trust. We pour it over so it goes according
the
to
title goes to the trust after you get through probate.
Yes.
And then it gets distributed based on the language of your living trust.
Yes.
Okay.
We've only used it one time.
Yeah.
But so what I want to say one more thing about the petition process. Let's say you don't have a schedule of assets at all, and you bought a property at long after you've set up your trust. I've had this happen too. We cite a different case, Ukestad, where we put it in every trust that you intend for all your assets, whether acquired before or after execution of the trust, to be in the trust, and we relied on that phrase. Or a general assignment that says you intend for future assets to be in the trust. We've gotten it in that way as well. So you can get through. We always want to do the simplest way of getting things in the trust, so we do that. But
Speaking of that, how should a person handle their personal property?
well, again, I don't want anything to go by will. So when people have gifts in their or personal property in their will, I don't like that. We do a general assignment with one pager saying all my artwork, jewelry, etc., is in my trust. And then we say that it can go by a memorandum if you leave one for such purpose, and if not, then it go by however we say it in the trust. But we'll give you a personal property memorandum. You can create your own, just say item, person, item, person. You can change that on your own. There's no titling on a watch or anything. So, that's going to be.
So that's called an assignment.
We
So
assign.
you draft a document that basically is 2 paragraphs long, and it says, I assign all my personal property to the trust.
Yeah.
And then the trustee with that document handles all of the personal property.
That's right. Mm-hmm.
And does that work for music royalties, copyrights, anything of, I guess maybe highly valued personal property?
Known people that have used it, but if we know you have royalties, we typically will do a separate assignment of that, the intellectual property and things like that. We'll do a separate assignment.
Yeah.
And they'll also, we assign, like I said, interests in LLCs or corporations or limited partnerships, we assign to the trust. And by virtue of that, the business interest is in the trust, and you don't change title in your business account, but by virtue of assigning it, the business is in the trust. So,
So if somebody has an LLC, as a corporation, S corporation, the stocks are titled in the name of the trust, or how does that?
Well, typically we'll give you the assignment. We'll say, I hereby assign my stock to the trust, and I hereby name so-and-so as attorney of fact to change it on the books and records of the company. Now, we don't do that, has to be done out there, but we do the assignment and then they take care of it from there.
Yeah. So the whole goal is to have all of your assets signed in this revocable living trust, which is just essentially a contract. And, and does a person have to change their tax ID number? Do they have to, is it when they put their home in the name of the trust, does the property tax all of a sudden go higher?
These are great questions. So I have people that ask this all the time. They're at the bank and say, what's the tax ID number of my trust? I said, it's your own social security number. There's no separate tax ID number. This is not an entity, it's you. So it's just really your own social and everything. You don't pay taxes any differently. You don't, no change in property tax or any taxes whatsoever. No.
Yeah. What about if somebody just owns their business in their own name?
Yeah. Well, if they have a business account, we'll do an assignment of a sole proprietorship to the trust.
Okay, so that would be a separate assignment that you would prepare? Yeah. So another question comes up because title is so important. If my husband and I change a joint tenancy property to community property, will we be liable for taxes on the value at the time of the change of title?
No.
Oh, no.
There's no property tax increase on transfers between spouses or transfers into a revocable living trust.
Okay, let's go to the next slide.
Okay. People will call me all the time and say, I want to set up a irrevocable or revocable trust. They don't know which one they want. I will tell you, you want a revocable trust as a starting point. Everybody needs a revocable living trust centered estate plan, like in the diagram, as the centerpiece of your estate plan. irrevocable trusts are typically set up when you have other situations like gifting. You have a very large estate, you want to gift things to children or things like that, or you want to put life insurance in an irrevocable trust so it doesn't become subject to estate tax at death. So revocable trust can be changed, irrevocable trust can't be changed, with some caveats. We're always in court, seems like, modifying irrevocable trusts. Even we have one where I just filed today, I guess morning, where we're just the terms were harsh, and we're trying to modify it to be more in line with what we think it should be. And I think it will go through. We've had been successful on every single one. So we do that. Now, irrevocable, and of course, a revocable trust becomes irrevocable at death. And
Or
then
incapacity.
they become, yes, as a
I mean, they don't label
practical
it.
matter, yes.
Yeah, they don't label it as an irrevocable trust,
As a
but
practical matter,
you have to have capacity
yes,
in order to change
exactly.
a trust. And, uh, sometimes that's not by the way, capacity when you're drafting these documents is a huge issue. And it's not a doctor's note or examination. Yes, that can be helpful, but what Leslie, when she determines your capacity, is that you probably go, do you know probably how much you have? Do you
Yes,
know the bounty
yes,
of where you're going to be distributing your assets?
yes.
It's a little different than the medical capacity.
Yes. So if I have questions, I really hesitate to draft for somebody who doesn't have capacity. But yes, we do. As a practical matter, you can't change your trust once you've lost capacity, but you don't have to get a new tax ID number or anything at that point, because it's still under the person's social security number. But the successor trustee steps in and then can be put on title to accounts and things like that. But when somebody dies, yeah, then you get a tax ID number, and then the taxes are compressed on an irrevocable trust and things like that.
What
So
I
most,
see,
go ahead, don't
no,
need a.
no, no. On the irrevocable trust, where I see these being used is when attorneys sell the legacy trusts
Well,
that go on forever.
mhm.
And I call those the fees and perpetuities trust. Do you, and the tax ramifications are huge that, look at the slide here on the second point. Compressed tax rates, irrevocable trust pay tax at the top bracket 37% when undistributed taxable income exceeds $15,000.
Oh, yeah, right. So that's
It's huge. Talk a little bit. What is a trust protector?
if ever I drafted an irrevocable trust, like a irrevocable life
Or
insurance,
even if in a revocable trust?
I sometimes put them in a revocable trust, especially if there's a special needs trust embedded in it, because who knows if the laws need to be changed. So a trust protector is there I have a hard time putting them in trust because people can't even come up with trustees, let alone trust protectors. So, but that person basically protects the trust. If there's a vacancy in the trustee position, they can appoint someone. If the trustee is looting the trust, they can remove them. If the tax laws, if something changes in the law that the trust would need to be changed, that's why I put it in special needs trust for sure. They can change it. So it's to protect the trust basically. And yeah, so that, like I said, I'm in 2 trusts as a trust protector, just as a favor, no payment, just in case something goes wrong. Yeah.
Yeah, it's if you have trustee successorship. By the way, do we? I can't remember if you have a slide on this, but who should people name as a trustee
Oh
in the
boy.
family?
Oh,
Because most people.
I thought you had a whole class on that one, but
Yeah, we do, but I just wanted to touch base with you on it because you're the legal counsel.
yeah,
Let's go to the next slide while we talk about that just a little bit.
okay. I will tell you that most people seem to name family members, friends, professional trustees, and as a last resort, corporate trustees, typically. That's what I see. And I don't know, is that what you?
Yeah. Oh, yeah, absolutely. But I mean, you probably have a conversation with people when who should they name in the family as is it should be the male in the family? Should it be the oldest? Is that how you pick someone within the family?
Yeah, no, it's not based on that. It's based on who's the most responsible and, capable and local. And there's so many factors that go into it. What's really difficult is when people want to be fair to all their kids and want to name all of them, even if they don't get along. And that's like, you kind of have to try to manage that one because that's difficult. I
Yeah.
mean, and so I'll have to say, what if they can't agree? And can we, name somebody to step in or something? I don't know. So yeah, that's a discussion. In fact, that's one of the more difficult, besides the distribution of the estate, who to name a successor trustee is like very, very
Yeah.
important. Yeah.
Yeah. The two most important parts that are very personal to each individual that you see as a client is the trusteeship and then also the distribution.
Yes.
Yeah, now those two areas of the contract, people really need to understand and focus on because
Mhm.
if it doesn't state in there that it can be a trust protector, it doesn't happen.
Mhm.
If it, you don't, if your trustee is named the same age or older than you, and they die, and you don't state in there what happens after that, there's a problem.
That's what I
So
do
you
put it
know,
in
uh,
the
uh,
language, yeah.
so
And
make
name something.
sure make sure you understand that. So what are some of the benefits of being in a revocable living trust?
So it avoids conservatorship upon incapacity and probated death. That's number one.
How does
And
it do that? How
because
does
the
it?
successor trustee just steps in at incapacity. Let's say you say if one doctor says uh, so we get a letter from a doctor typically on a tear off prescription pad sheet or a letter. Usually if the trust says one doctor, they get that, they're in charge. They can go to the institutions and get on title to things and handle things. They
So
can get
this
on,
is in the trustee section.
yeah, they can
Yeah.
get on title to a house, get a HELOC and pay for the assisted living. They can do all kinds of things. So it's great.
So
Um,
so please take a look at your trust document at the trustee section. Do you put in one? Is there one doctor that has to give a letter, or is there two? Getting two doctors today to tell required before the successor trustee steps in. Next time that you need to review your document, you may want to change it to one medical doctor. It's just very difficult today to get two medical doctors to state that you lack capacity because of the liability they believe is involved. If your primary knows you, the secondary doctor may not know you, and it makes it difficult for the successor trustee to step in.
yeah.
Can the power of attorney control and that you named as the agent under the power of attorney or the attorney in fact, can they have any powers over your living trust?
No, well, people think powers of attorney are extremely important documents, but they can't change your trust unless you say they can in the power of attorney. No, but we do say in the trust that you can name a power of attorney over your trust. So in that case, you
But
could.
it's a completely separate
It's a
item. So,
document,
but
yeah,
powers of, when
yeah.
somebody asks me to be their trustee, for example, the first thing I do is go through the assets and see how they're titled.
No,
Because if it's titled in your own personal name, then I have to put my durable power of attorney hat on.
yeah,
If your asset is titled in the trust, then I have to put the successor trustee hat on.
that's
So I
correct.
see title, and it becomes very important at the
Yes,
time if you suffer from some sort of incapacity, a stroke, Alzheimer's, Parkinson's disease, etc.
right.
So to me, this living trust is all about incapacity.
Hmm.
Assets are distributed without court involvement.
Yeah.
How long does it take for a trust to be administered?
Well, within 60 days of death, you have to send out a notice to beneficiaries and heirs at law, notifying people that the trust became irrevocable. And then they have 4 months or 120 days to contest the trust, after which you you can make distribution. So minimum of 6 months.
Yeah.
But
So
some,
most times 7 to 12 months, depending on your assets, how they're titled,
right?
where they're located, how
Yes,
much personal property do you have?
yes.
But many people believe that, hey, I have a living trust, so can't I have my money tomorrow?
Instantaneous. No, it doesn't work like that. There's laws that we have to follow.
Yeah, the beneficiaries are interested in two things usually upon your death: how much and when.
I was just,
So it takes a little time.
yes, that's true.
Um,
I will just as an aside, when you leave things to people, you can leave it in trust or not in trust. That's another thing we walk through and talk through during
I think you have a slide on that. You want to go to that? I think it's the maybe.
it is. But let me just say one more thing.
Okay,
Another
sure.
thing, if you own property out of state, it's
Oh,
even more important to have a trust because you'll avoid a probate in California and a probate in all these ancillary states. If you have property, if you have a trust, you can deed all your properties in all the different states into this trust and no probate in any state. So that's so important if you have,
huge.
yeah, it's huge.
Yeah, yeah. I just had
Mhm.
through having a probate in Nevada
Oh,
and another one in Colorado.
wow.
And people have vacation homes
Yeah,
and
yeah,
please get them all titled in the
yes,
name of the trust.
yes.
It will
Oh,
save you thousands of dollars
yes,
and a
yes.
headache.
Do you
Uh,
want to go ahead or can I just go through here? I mean, I don't know where that thing is about trusts right now at the moment.
okay, we'll get to that. How about the drawbacks?
Okay, costs money to set up, but because it's out of your pocket and the probate's out of your beneficiary's pocket, but it's a lot
Yeah.
more. There's no oversight. So if if you have a bad
You mean no oversight by the courts?
by the court, yeah.
Because
So
beneficiaries are definitely going to see to it that you do whatever you need to do properly.
yeah, so I mean, there's a newer law now that when before, we do send out notices at death and people are entitled to a copy of the trust and everything. But then they changed the law so that when somebody becomes incapacitated and a trustee steps in, now they have to notify people because there was a time, I guess, between, incapacity and death where people were looting trust, bad people. So bad trustees. So anyway, there's no oversight.
By
So
the
that,
way, yeah, when we talk about problems, it usually happens within the family.
I agree with you. It's the family members.
Yeah, it's not
It's not the corporate trustees or professional trustees.
or but there's a whole movement out there since Britney Spears that
Oh,
and even in Britney Spears, the problem was the family members,
yeah,
within the family.
yeah.
It's you have to be honest and objective when you talk to your attorney about your family.
Yes,
They
yes.
can set things up appropriately if they know. If they don't
Mhm.
know, then then they can't put in the appropriate terms.
Right.
Remember that your living trust is a contract, and that terms of that contract is written there. I many times I get the question, "Hey, mom gave us $15,000 a year at Christmas time. I'm assuming that you're going to continue doing that as a successor trustee. And
Well,
what if
during
and I,
incapacity, you're
huh?
saying during incapacity?
Uh-huh.
Okay, yeah, if the trust allows for it, you
Yeah,
can and
and when
power.
you say allows for it, it states in the trust
Yeah,
that I want my successor trustee to continue making gifts during my incapacity.
yeah, we put it in the trust and power of attorney if that's the case, but most, yeah,
That's
yeah,
And your living trust for a successor trustee is the Bible.
right.
Not what people tell me, it's what is written in that document. What are some of the common fallacies here?
Yes, so many people think a revocable living trust provides asset protection. They said, I need a trust. I got to protect my assets. It doesn't protect your assets at all because a creditor stands in your shoes. If you can get the money, which you can, they can get it. So it doesn't provide any asset protection. However, you can build in asset protection to third-party beneficiaries. You could give them a very, because it's coming from you to them, you can put in terms that really protect them from creditors. So it's up to you. That's something we talk about if somebody's a high risk at liability, a child or something.
Yeah.
And like I said, there's no change in the tax ID number at all till someone dies. And then we have to get, because you can't use a social after someone dies, you have to get a new tax ID number for the trust.
Yeah. If somebody asked a question as to what happens, or what do you tell your family members or people that you've named in the as beneficiaries in your trust when somebody steps in because someone is incapacitated.
But you tell
So,
them?
what do you tell them? I usually go to Leslie and say, Leslie, would you write the beneficiaries a letter stating the situation so they understand it?
Right. And then under that, if somebody becomes incapacitated and the trustee steps in, they have to provide an annual accounting to those beneficiaries. So anyway, just
Yeah.
so.
So there's a lot of oversight by the beneficiaries because they're very interested in what happens with the trust during incapacity. And that accounting becomes really important. And if there's a family member that steps in as a successor, recommend highly that the successor gets legal counsel to assist them
I agree.
because there's a lot of pitfalls.
Oh, it's very important to follow the laws to protect yourself from liability as a trustee.
Yeah, you
Anyway,
know,
oh, go ahead.
no, I was just gonna, what's the difference between regular liability and fiduciary liability?
Well, it's a higher standard. It's like, yeah,
What does that mean, higher standard?
well, you owe that person, I don't know, you could probably explain it better than I, being a fiduciary, but it's just you put
You
their,
have, let's say you have three choices and one is okay, the other one is okay, but there is a best choice. Uh,
yes,
yeah, and under normal liability, you wouldn't be liable if you choose either of the three choices. Under fiduciary liability, you got to make the best choice. And the probate code has a list of all the specific fiduciary rules, which we'll go over in week 6 when we talk about estate administration. But there's a lot to being a successor trustee.
the highest level of duty to the person. Yes, it's the beneficiary,
We
etc. Or
we
the
talked about funding, but you know how important it is when we talk about funding. We're
yeah,
talking about changing title.
right. And I will say, so people get very confused about retirement plans, and I know you have a whole session on it, so I'll just touch on it briefly. As a starting point, you have to think everything should be titled in my name as trustee of the trust, except for life insurance and retirement accounts generally. Life insurance, it would be in a separate trust if we'd had one, but those pass by beneficiary designation. Now,
That's
retirement,
on the next slide, just so you know.
so retirement, in a perfect world, you would name beneficiaries directly on retirement accounts, but sometimes we'll name the trust if there's minor children or we want to control it so they don't take a lump sum and things like that. But more often than not, we want it to go directly to beneficiaries. Life insurance, we typically will name the trust the beneficiary, because I've had it where a husband died, his life insurance went to his spouse, she lived 5 days, died, went to probate, $1.3 million, because even though there was a contingent beneficiary, she had vested in it and did not name new beneficiaries. So ideally, in my world, I like to name the trust the beneficiary. So there's backup people in case someone dies or that situation happens. Let's see.
And then, yeah, the trust is a beneficiary. That's why titling, how you have titled assets are just so important
Yes,
and have ramifications.
yes.
Uh, when somebody receives an inheritance, is that community property to the person if they're married, or is that separate property?
That is separate property unless you commingle it or transmute it in writing. So let's say you inherit a piece of property. You can deed it to the trust in both your names as trustees, and our trust will say it retains its character as separate property. So if you divorce, it goes back to you. But if you transmute it on the face and say it's now community property, I won't do that, but I'll let them do it if they want, not with me involved. But then you can transmute it if you sign a community property agreement.
Transmuting means
Means writing on it that, a written transmutation, like
changing title from one separate property to community property.
signing a community property agreement.
Yeah.
Or you get the inheritance and you get an inheritance of $50,000 and you stick it in the joint account. That is commingling, and that now makes it community property. So
Yeah.
if your spouse leaves you the next day, they get half.
Here's another, how you title property, real property, sole owners or tenant in common,
Yeah.
timeshares,
Yes. Sometimes it's deed, sometimes it's points based. Yeah.
co-ops,
Co-ops, like
Laguna Woods.
Yeah, some of those are co-ops and they reissue by certificate.
Yeah.
And again, as out-of-state real property, we have contacts in many states that do our deeds in other states and get them in.
Yeah, the next slide, we go through some more titling.
Yes, bank and brokerage accounts as a general non-retirement, non-business accounts, retitled them. And every now and then we'll have a spouse that they want to keep things separate and they want to play money account that they don't want their spouse on. In those instances, or like a Amex or Discover, the ones online that pay more interest and don't have services, they won't let you put it in the trust. On those, it's okay to name a pay on death or transfer on death beneficiary and not have it in the trust as long as it's not the bulk of your estate, because we want money in
And
the
$20,000 is fine,
yes,
but
right.
People are confused when they put their bank account in the name of the living trust. It does not mean that your checkbook, for example, has to state living trust.
Oh, if
In
you
fact,
wanted to, but you don't have to. No,
no, I wouldn't put it
I
on
can
there.
either.
I wouldn't even put my address or phone number on
Yeah,
my checks.
yeah.
So there's no need for anyone to know other than your name. Banking has changed dramatically. So, but you make sure just that it's the right title.
Right. Behind the scenes, it's in the trust, and you don't have to show anybody.
Yeah.
Also, what was it'll come back to me. Oftentimes a parent will put their child on title on an account. And I'll say, why don't we just name them as a co-trustee? I can give them paperwork and make them trustee as to just one account or two accounts or five accounts or only financial accounts, not real estate. So we can do that. And then at least it will go according to the terms of the trust at death and not all to that child as the joint tenant.
What about some other assets? I think it's on the next slide. Business interests, by the way, we talked about. If let's go to the next slide.
Okay.
And we're talking about other assets, safety deposit boxes. Please put it in the name of the trust.
Yes, I mean, do that. And then promissory notes, if you have loaned somebody money, we assign that to the trust.
Family loans. Talk a little bit about that.
Well, we just assign it to the trust so that it goes back into the trust and gets after death. So
if you loan money to one of your kids and you have more than one child, should you have that note in writing?
what I do when people advance money to children, and they may even do more, they may pay it off, I usually give them an advancement schedule to attach to their trust and say, at death, it's going to be, the distribution will be adjusted by the advancements they've made to children, so that it's fair.
Yeah, it's a huge issue within estates if you don't have something in writing, because the kids that didn't get the loan are going to want the kid that got the loan to have it repaid. the person who received the loan is going to likely say, hey, mom said that this loan is forgiven if I don't pay it before she dies. And
Right.
if you don't have anything in writing, there's nothing to prove one thing or another.
Yeah.
So
Yeah.
it's a huge issue. What about paper savings bonds and paper stock certificates?
Well, we do that with the bonds through treasurydirect.gov. I usually have people do it themselves rather than paying me to do it because it's a hassle. Same with mobile homes. It's a hassle. I'll do it, but it's probably better to do it yourself.
Yeah,
I give you a sample and you can do it.
yeah.
It- but stocks we like stocks in the name of the trust. Yeah, we don't want anything
Yeah,
out of the name.
please don't. Paper today is probably the worst way to have title to assets or to keep ownership interest.
Yeah,
You want it filed. Open up a Schwab account
that's what we say.
and put your saving bonds in with the Schwab account.
Mhm.
Put your stock certificates while you are alive in that Schwab account. It doesn't cost you anything. It's absolutely no charge. And then hopefully that Schwab account is in the name of your trust. And so if something happens to you from incapacity point of view, the successor trustee just steps in and can manage it. You
Yeah.
know, whereas if you have paper saving bonds, or you have a safety deposit box, or if you have a stock certificate, all of those has to be handled through paper.
Mhm.
And
Mhm.
it could take quite a while, and it's expensive
Yes.
administration.
Yes. And so we usually say go to a just open an account and put it in there. It's just like you
Yeah.
said.
How about
Car
cars?
People ask a lot about cars, but you can put them in the trust, you can retitle them, but it's such a hassle and it's so easy. Well, relatively. At death, you go to the DMV or Auto Club office if you're a member with the small affidavit you can get online, a death certificate and certificate of title, and it's yours
Hey,
basically.
Dave, Triple or Auto Club, they'll provide it for you.
Yeah, it's real
You
simple.
know, it's
It's
very simple.
it's very simple, and also it doesn't cars avoid probate, even if it's a $250,000 car.
Yeah.
It doesn't go through probate. It's just, this is the way it's transferred. Vessels, we've done some transfers of vessels into the trust as well using that
Yeah.
coast form, but again.
But if you do have a car and you're married, you may want to put or Joe Smith
Perfect.
or Mary Smith instead of Ann.
It's perfect.
So it's just makes things a little bit easier. In fact, you don't even have to change anything if you use the word or.
Yes, that's correct. Also, I'm just going to skip ahead to the biggest issues we have to address, which we talked about a little bit, but I just want to go over a little bit.
Sure.
The definition of incapacity is important. Beneficiaries are very important, but not only the beneficiaries, but who the backups are if the person is deceased, and the manner of which they're getting it: outright, in stages, in trust, asset protected trust, adjustments or advancements. Like I told you, I'll provide a schedule that can be updated by the client, and then the remote contingent if everybody's gone, so things like that are important. We didn't touch on taxes, but because and it's not as important nowadays as it was in the past at this moment, because the amount you can pass free of tax, you can give 18,000 to as many people as you want every year, plus direct gifts to charity or medical care are not subject to this overall lifetime exemption you have. It's so large. 13.61 million per person you can give free of tax during life or at death, combined. If you give any person more than 18,000 a year, you're supposed to file a gift tax return that will chip away at that overall exemption.
Let's go. Let's go to your slide. Married couple first death 2024. And
I made it really high. Well, no, I didn't. Okay, well, so this is the standard procedure. This is what.
before we go there, in the distributions section of the living trust, you get to state how much, let's say if you have 3 children, how much each children will have. Most times, if you want to do it equally, if you do it unequally, please have a good reason,
Yeah.
because usually that brings up a lot of issues if you do it unequally. And talk to your attorney about the benefits of not doing that. But so make
If,
sure of that.
if it's unequal, I always, unless they have a statement as to why. Because if you don't say why, they imagine all kinds of things like
Yes.
undue influence, or they hate me, or sometimes they have a valid reason. And so I would try to word it in the nicest way. Like,
But most times, if you're a married couple, you leave it to survivor spouse. So in the old days, in order to take advantage of the estate exemption,
yeah,
then you would want to have what's called an exemption trust and a survivor's
we'll
trust.
call it
But if you
AB
go,
trust.
yeah,
Yeah.
an AB trust. So for people out there that have an AB trust today, please go back and see your legal counsel to see whether or not that's still appropriate, because taxes have changed. But
Yeah.
let's go back to your other slide
Yeah. So the other slide
at the
today,
24. So this is what you should be doing today.
typically, if you're a couple that has the same children from the same marriage, and you don't trust your spouse and everything, we're going to leave. If you both own a share of the estate, community property estate of 8 million, each have 4 billion each. The decedent will leave his or her share to the surviving spouse in a survivor's trust. The trust basically just continues on. The surviving spouse can change the distributions though, and spend it all, do whatever they want. But you can pass two exemptions with this type of plan. We file what's called a 706 estate tax return to port. That's the term of art. The deceased spouse's leftover exemption to the surviving spouse. So right now we're porting, whatever 13.61 million. The surviving spouse, whatever they have at their death, will be able to use as well. Now that the exemption is scheduled to drop to 5 million in 2026, adjusted for inflation. But we don't know. It could change anytime before someone dies. But we do want to take advantage of a high exemption by filing a 706, usually right now, if
Yeah.
it's a large enough estate. You can, if you don't have to leave everything to your spouse. Outright in a revocable trust, you could put it in the irrevocable trust and control it. So and you force it into a mandatory.
Sometimes you do that for purposes of a second or third marriage, where you want to make sure that the first marriage children get the benefit of the estate. So there's lots of tools in your chest that you can take out and help people with.
So there's all different types of arrange. You just talk to them. I don't like to impose my views on it. I want to hear I tell them the different options, and they tell me what they want.
What
And
is
I
this
decide.
today? Instead of an AB trust, most attorneys, if they are understanding this stuff, use what's called an AC trust. What does that mean for a married couple?
Okay, it gets a little complicated in the tax arena, but what it means is the surviving spouse wants to control his or her share by putting it in an irrevocable trust, but wants the second step up in basis. Because when you put things in a bypass trust, it bypasses the state tax and it will never be taxed again. But there's no step up. There's a step up in cost basis at the first death, no step up in basis from the B trust to the kids. So if the state is So if you don't have a tax issue, you really want to just control. We'll put it in what's called a C trust or a Q-tip trust. And so there's a second step up at the second death. However, if the state becomes large enough that they want the bypass trust because their state's over two exemptions, they could disclaim to a bypass trust. So we have all these options built in, and the clients can, within 9 months of death, do disclaimers and all kinds of things. So because we don't know what the tax laws will be, we have a lot of flexibility built in. And then we put in the very front of the binder, it's imperative that when a spouse dies, come see us so we can tell you what's our options, what's the tax laws, and what should we do.
Yeah, and then if we go considerations for distributions,
Uh-huh.
we're talking about subtrust.
Yes.
And subtrust means this is that instead of them receiving a check for, let's say, $300,000 as a distribution from an estate, you put it into a subtrust. And what does that mean?
Well, we find that most
Special needs, for example?
yes, definitely. Special needs trust, pet trusts. We have all kinds of sub-trusts. Typically, we want to, an inheritance, like Peter was saying earlier, is separate property. But often when you inherit, there's pressure from the spouse to put it in the joint account. If a child inherits in trust, it makes it easier for them to keep it separate. So often, more often than not, we'll leave assets to children in lifetime asset, well, lifetime beneficiary control trust. They can be trustees at a certain age, but it comes into them separate. It's not, it can't, it's separate property and it stays that way. It's easier to keep separate, but they can do things that it depends. If you can put controls on it, you can put incentive trust provisions matching their W-2. You can do all kinds of things, but more often than not, we're just going to have a basic trust. They can be their own trustee at a certain age.
Where I see this being used is a lot is that my daughter is married to an outlaw. He is an in-law, but he's an outlaw. And I want to protect my daughter from him.
Yeah.
And I suspect a divorce within 5 to 10 years. So the last thing I want to do is to give it to my daughter outright, because more than likely they're going to commingle and put it in a joint account. And upon their divorce, that money is going to be split. Whereas if I left to my daughter in a lifetime benefit trust, that means it would stay her separate property, or it would be easier to maintain her separate property.
Yes, and if you were concerned your daughter would be influenced by the spouse to take it out and put it in the joint account, then you could put a different trustee over it,
Yeah.
making distributions for her benefit until she was, 50 or 60, or, you can do whatever you want. It's sky's the limit, really.
But just understand there's extra administration costs. You have to get a separate tax ID number, and that asset has to maintain its separateness. So
Yes.
it can't be commingled. How
Right.
about distributions at a particular age? Is 25, you think, mature enough to for some?
Child, I always ask the clients what they want. I have it everywhere from 18 to 65 as the initial distributions and things. So I
But you
find
can
25
control
or
that.
30 is common. You could, yeah, 25 or 30 is common. It's usually based on their own experience growing up of what they think when they became, responsible adults.
Okay.
But yeah, uh, what else I was going to tell? Oh, regarding, there's a tax return every year for a irrevocable trust, which a beneficiary controlled trust is an irrevocable trust is established at the death, and we want the income distributed, of course, so it's taxed in the beneficiary's tax bracket, not the compressed tax bracket of the trust. So I don't know if we really need to talk about the Prop 19.
No,
Okay.
a lot of times people want to. We talked a little bit about the pet trust and the
Yes, we did.
supplemental
We
needs
did.
trust, but let's come online and we'll do away
Fine.
with the slide presentation.
Okay.
And come on in, and Eugene, come on in as well. Let's just have a little roundabout conversation, because this is the centerpiece of an estate plan, is that living trust. Any questions out there that you want to, Eugene, that you see? And
Well, let's do a closeout real quick,
okay,
just for the video. So for now, I'll ask, we'll say our goodbyes, and then we'll be back just 1 minute after I do the outro. So I'm gonna shut off your mics and video just real quick. But Pete, thank you so much. Leslie, thank you so much for your time. Let me also go over the website. So I want to thank an audience member for pointing out that the content on our website is back up. But I'd like to share the screen so that I could review where to find everything. There we go. So this has been Financial and Estate Literacy iyme.org. It's yourmoneyandestate.org. If you go to workshops and go to It's Your Estate, this week is week 3, wills and trusts. This is where you'll find our website, our videos. And down in our outline, you'll find the outline for Leslie here, as well as the Ask First form. They are now working, as well as the articles down below. Again, everyone, I thank you for your time. This has been Financial and Estate Literacy. Have a good day.